Please stand.
Okay, Council, you may proceed.
Good morning, honorable members of the Supreme Court of Lionsgate. My name is Ms. Barbosa, first initial L, and this is my colleague, Ms. Mackay, first initial H, and we represent the Attorney General of Canada. The case at bar deals with limitation placed on the voting rights of defendants who have chosen to leave Canada for more than 5 years. Our position is that the Supreme Court of Canada erred in their decision, and as such, we respectfully request that this honorable court overturns the decision from the lower court and allows the appeal. Would the justice like a summary of the case?
No, we're good, thank you.
Today, we have 4 submissions to make. Our first submission is that ensuring that electors maintain some relation of currency to their communities is in fact a pressing and substantial issue. Our second submission is that there is a rational connection between the parliamentary objective and the limitation it places on Section 3. Our third submission is that the impairment caused by the limitation of the legislation is in fact minimal because it is temporary. And lastly, our fourth submission is that there's proportionality between the limit and the parliamentary objective. I will be addressing the first 2 submissions, and my colleague will be addressing the latter 2. As previously mentioned, our first submission is that expanding the franchise while ensuring that electors maintain some currency to their communities is in fact a pressing and substantial issue. Preserving this relationship between electors and their communities ensures that there is reciprocity. People elected lawmakers they believe will address in the best manner their priorities and the issues of their community, and in turn, they will be affected by those very same people that have chosen and the laws that they amend and create. This ultimately ensures that there is fairness among citizens, because again, as I said before, they will be affected by those laws that they have
Council?
passed.
Now, I wonder if fairness for all citizens would include non-resident citizens. Now, if you would care to expound on the idea of fairness and as well as currency specifically. So what does currency mean to communities?
If I understand your question correctly, you're asking with respect to the value of the relationship?
I'd like a definition of currency to communities, and I'd also like to understand what your definition of fairness is in this regard with relation to non-resident Canadians.
With respect to currency, we refer to the fact that a person that has an elector that has currency to their communities is a person that is involved in the communities, that is aware of the issues and the problems that our communities are facing, and is therefore better informed to engage in their voting rights.
Council, would you concede that there are some people that do live physically in the communities, however, they are not actively involved, and they still have the right to vote if they're presently in Canada?
Even if that is the case, they're still part of that community, and they still have some sort of knowledge of what's going on because they are present in that very same community.
Well, I guess definition of present may be different. Physically present and then present by being involved? Or do you not have the difference between the two?
Your Honor, it is our submission that despite the fact that not every single citizen may be voting with the exact same level of knowledge, a person that is living in a community, whether they like it or not, they will still be involved in the issues that the community is facing. And they're still, and in a way or another, they're still aware of the problems that our community is facing. If I may proceed.
Proceed.
The social contract principle has been, and is, and will be an essential element to democracy. As Canadians, we are subject to the laws of the country where we live, from very minor laws, such as allowable crossings, stop signs, all the way to extremely important issues, such as payment equality or marriage.
Council, how does residency equate to fairness in an electoral process?
Residency equates to fairness because the people that are living here are receiving the full burden of the law that they are actively being part of. So a person that is living in Canada engages in their voting rights, and the people that they're choosing will go to court, will go to Parliament, and they will represent them. They will act on their behalf. And that's where the fairness comes from. The person will be subject to those laws that they themselves took a part in choosing, because they're electing the people that will make those
Council,
laws.
let's say you to the fact that when it comes to residency, it's quite easy and quite simple these days to change residencies, to change your jurisdiction in terms of where you're living within this country quite easily. It seems to me like you're putting a lot of emphasis on where individuals reside. So what say you to the idea that where you're living in terms of electoral is just an organizational framework? That's just about organization as opposed to something that you're putting much more emphasis on?
Your Honor, it is a submission today that in addition for it to allow the process of elections to have reason and for it to seamlessly take place, in addition to that, it also provides for, as I mentioned earlier, echoing and providing these communities to be able to have a say on what their issues are. So even while a person may, for example, move from Richmond Hill to Newmarket, they will still be part of these communities. They will still be present, and they will still have awareness and understanding of the issues that these communities are living. It is that presence that makes the difference. The respondents on this case live in America and are subject to the same level of laws that are previously indicated, but in America because they reside there. By living abroad, they do not have to worry about things such as applying for a Canadian certificate to get married.
But don't they have properties in Canada, and don't they pay taxes? Don't they have ties, connections? Wouldn't that qualify?
Your Honor, while the respondents may still have connections, as I mentioned earlier, it is our submission that the effect and the burden of the laws will simply not be the same. We have earlier spoken about the social contract, and I again mentioned the fact that being part of that community is essential. In fact, I would like to quote at this point Justice LaBelle and Canada and Figueroa. One of the components of effective representation is the interests of citizens being represented as members of regionally or territorially defined communities. So while a person may still have some type of connections, it is that territorially defined communities that makes the difference. We're talking about people
Certainly, we
that...
find that in Section 3 of the Charter. Section 3 of the Charter talks about a democratic right to vote, and not any one particular first past the post Westminster system. That's just a choice or a preference that Parliament has provided over the past 150 years, but that's not what Section 3 is about, is it?
Your Honor, Section 3 refers to the fact that as a citizen, you're obviously engaged, you obviously have the opportunity to vote. That's what Section 3 says. However, it is our submission today that it is very well within Parliament's power to provide limitations for sections such as Section 3.
So you're elevating the first past the post system to a constitutional charter level type of right. That's what you're doing here.
Your Honor, it's a submission. Respectfully, that's not what we are trying to address. What we are submitting today is that having people in Canada be represented by their MPs is essential to democracy because they're reflecting on the issues that the communities have. And it's the social contract aspect that makes the
Council,
difference.
how do you make the argument and reconcile where communities are not affiliated with the land per se, but with the indigenous, say, people? So if I have my indigenous rights are from or flow from, say, Nova Scotia, but I reside in Ontario, my community, technically speaking, for all intents and purposes, is in Nova Scotia, but yet I have the right to vote. So how is just occupying the land somehow legitimize my right to vote?
Your Honor, it is our submission that while a person, like the example that you gave with indigenous rights, will perfectly, it's 100% understandable that they will have this connection with the indigenous lands. The fact that they're part of the new community also influences their vote and also influences how they're voting. So one doesn't take over the other. You may move, as I said earlier, if I live in Toronto and I move to Newmarket, but I'm voting Newmarket, I'm in part of the Newmarket community and I'm voting based on the issues that are going on in Newmarket. The fact that I have a connection to Toronto doesn't take away that I have an understanding and I care deeply for the new place where I'm at.
But 60% of the people that you're talking about here won't have any right to vote at all because they don't have citizenship in the countries where they live in.
Your Honor, if I hear you correctly, are you referring to the permanent residents? Or
These are non-resident citizens who are around the world not living in Canada, but they don't have a right to vote in the country that they're in. So that analogy between Toronto and Newmarket doesn't work.
Respectfully, Your Honor, while they may not have the right to vote there, they're still being influenced by the laws there, and they're subject to the laws there. Our submission is that the people that are here in Canada are suffering the consequences of people who are not here.
Why? Why would they be suffering the consequences though?
By engaging in the right to vote after the 5 years have presumed, let's pretend for a moment that they have left the country for 20 years.
So if you refer to paragraph 111 in the case of Barr, and on the second page it says, the first page, and it says, whether the prohibition on long-term non-resident voting is reasonable, and it continues about section 3, it says requires all citizens regarding of how long they have lived abroad, or even if they have never set foot in Canada, be permitted to cast a ballot in federal. What do you say to that?
Court's indulgence, I would like to review the paragraph
Sure.
carefully.
Thank you.
If I understand your question correctly, you're addressing the fact that all citizens, the issues that all citizens, regardless, they should be able to vote based on that.
Right.
Your Honor, is a submission today, as I previously mentioned, the fact that Parliament does have a power to set limits on things, and I apologize, on charters and on certain legislation. It is within their power to simply understand that there's some issues that rights cannot be complete, that they cannot be fully addressed.
But isn't section 3 a positive entitlement?
100% it is, Your Honor. Yes, it is. However, again, this is a right that still has limitations. So we see, for example, the fact that it is limited by the people under 18 cannot vote.
So
There's
you're
a
taking
limitation.
away that entitlement.
I apologize.
You're gonna take away that entitlement from the respondents.
Your Honor, with due respect, it is not taking away an entitlement. It is a temporary suspension, which is very important to address. It is a temporary suspension that is being put in place because Parliament, with, I'm sure, very deep analysis, has determined, as I put forward today, that the social contract that society like Canada in a geographically determined district is sufficient enough and it's important enough to address and therefore to put a limitation on that right in order to address that issue.
Where do we
Thank
find this social contract in the charter or any legislation?
Your Honor, while there may not be exactly a written social contract, there is nothing physical that we can grasp.
So what you're really giving us is philosophy.
Your Honor, it's not quite philosophy. I would describe it more as a principle, a very relevant principle.
But not a constitutional principle, right?
Your Honor, while this need not be a constitutional principle, it is something, it is very much valid in the sense that we are able to see this in effect in our country. We're able to see that communities, in Toronto, for example, have huge problems going on. And without this social contract being in place, we're telling these people in Toronto that are going through all this situation that a person living, I don't know, in China has the right to influence their votes.
Why should a
Even though that they're not
speculative
part of it.
counsel? Why should a speculative philosophy displace a concrete fundamental right?
I apologize, Your Honor, I couldn't hear you.
Why should a speculative philosophy displace a fundamental charter right?
Your Honor, I have been informed that I have a minute left. If it's okay, I would like to address your question, conclude my submission.
Please.
It is our submission today that we are not displacing a fundamental right. We are not displacing the right to vote. Again, I echo what I said earlier. This is a suspension, and it is essential to understand this. A person that goes abroad has 5 years. That within those 5 years, they're able to engage in their vote. Nobody's taking that right away. But they have chosen to stay after, fully knowing they have chosen after those 5 years to stay abroad, even knowing the consequences that means.
Doesn't Canada encourage studying abroad, moving abroad?
Your Honor, with respect to studying abroad, it is my understanding that a post-education program, such as 4 years to obtain a bachelor's, within that period of time, they would still be able to engage in their rights to vote.
So if I want to get 2 degrees, Canada encourages that, but then they're going to punish me by infringing on my right to vote?
Your Honor, it is our submission that despite the fact that it is your personal belief very respectfully that Canada encourages,
Please
it's okay,
conclude.
I would like to conclude. I conclude with the fact that the government's legislation on Section 3 is a pressing and substantial issue. It has a well-thought-of limitation that addresses the issue of losing connection to Canadian communities and thus affecting the integrity of the Canadian electoral system as per the social contract. Bearing any further questions, that concludes my submissions. My colleague will be addressing the letter too.
Thank you, counsel.
Thank you.
Thank you.
You might proceed.
Good afternoon, Honorable Justices. As my colleague has mentioned, my name is Mackay, first initial H, and I will be discussing the latter 2 elements of the proportionality analysis under Section 1 today, being minimal impairment and the overall proportionality. Our submission is that the measures in question impair the right under Section 3 to vote as little as possible, while still keeping with the pressing and substantial objective of ensuring that electors retain a relationship of currency with their community.
How does it do it minimally? It actually denies it outright.
Our submission today is that the limit is minimal in that it is temporary. This is not an outright restriction, nor is it a permanent impairment.
But 15 years would be more minimally impairing, correct?
15 years would be another alternative option.
But it would be more minimally impairing than 5 years.
Our submission is that in order to assess the minimal impairment must be measured in context to the objective.
No, I understand that. My question is, 15 years would be more minimally impairing than 5 years.
15 years would allow for a longer time frame for Canadian citizens to live abroad and retain their right to vote.
Which would be more minimally impairing, correct?
We would understand that this might impact fewer citizens. However, our submission today is that
I'm asking a very simple question. Is it more minimally impairing to have 15 years instead of 5 years?
The 15-year limit would be less impairing. However, in context to the minimal impairment
So why is your 5 years more appropriate than 15 years? That's the relevant question here.
Our submission would be that the 5 years falls within a reasonable range of alternatives that are open to Parliament.
Council, I'd like you to consider that what my fellow justice has essentially presented to you is an option that is, in effect, what you've admitted is as a minimal impairment. Minimal meaning the absolute least possible in order to obtain the same objective. So we're 5 years the minimal impairment. There wouldn't be a 15-year option. It would be 5 years. Why is 5 less minimally impairing, or rather more minimally impairing than 15 years? Why is 5 years the option? That's the question at hand today.
Our submission would be to that effect, would be that the 15-year limit might not achieve the objective of maintaining that relationship of reciprocity between electors and their communities. 15 years is much longer, obviously, and that would not lend as well to the objective.
Council, so help me understand this, Council. So is the community the land, or is the community the people and the social interactions and connections that that person has with that group of people?
Our submission would be that community could encompass both of these concepts. Residence is key to both of these ideas. Residence provides a means for a person to have that substantial connection with this more subjective community. Of course, communities in Canada are very diverse, and community membership may be measured in different ways. However, residence provides a pragmatic means of assessing that relationship with the community.
And your suggestion is that residence is the best way of identifying that connection to a community. Is that correct?
Our submission would be that residence, as well as time and distance from this residence, combined do constitute the best way of measuring a relationship with one's community.
So if a non-resident Canadian flies to Canada the day before an election, registers their residence in a specific riding, they can vote, though, correct? Under your submission?
Our submission would be that in context to the specific limits imposed and the procedural elements as imposed by Elections Canada, a citizen, in order to vote, need to regain that residence.
What's the process for that?
The process for regaining residence?
Yes.
At this time, I can't speak to the specifics of regaining residence.
But it's not a very high threshold, right? So there doesn't in fact have to be a connection at all to a community. Fly in, year of an election, get your residence, boom, you vote.
Were this the case and there were citizens flying in and impacting an election and then leaving, this would also create a substantial issue. I feel that we would submit that the issue you identify in this question is actually an issue of someone who is not part of the community coming in and placing a vote, and that issue would speak well to our submission.
So what I'm getting at, there doesn't seem to be a rational connection between what you're saying is a pressing and substantial objective and the actual type of measure that's being proposed by Parliament here. I don't see it.
Justice, Parliament is well within its authority to assess the best pragmatic means of achieving its objective.
Unless it's unconstitutional.
So,
Of course, Your Honor.
but Council, I think really what we're getting at, really what is the pressing and substantive objective here? What we're hearing is some philosophy about the social contract, but we're not seeing any pressing issue here.
Your Honor, the social contract is, as you have mentioned earlier, a philosophical concept that encapsulates the idea of effective representation. Effective
An
representation.
idea.
Correct. The idea of effective representation. Effective representation might be difficult to measure, however, it is a well understood concept, and we do reference this concept by using the social contract.
Council, sorry, how do you justify to us the idea or premise of this social contract and about connection to community when there are huge percentages of voters who live right next to a polling station who never bother to go out and to vote at all. And yet the process for these individuals who are living not within this country to vote means that they need to go out of their way, which to me would demonstrate a connection to your community, which would definitely demonstrate a connection to the country. And they go out and they create a space where they can do the special ballot, and they are able to vote. How do you reconcile that to us?
Your Honor, while a citizen in Canada might not exercise their right to vote, our submission would be that that is well within their rights. It's a positive entitlement. A citizen need not exercise that right. However, if a citizen is living abroad, and as you say, they are interested in voting, of course the onus is on them. It's a long process, which is why Parliament has allowed that 5-year threshold to encompass those people who are most likely or more likely to want to express that interest. Should a Canadian citizen be substantially interested and invested in the outcome of Canadian policy, they need only regain or reestablish their residence in Canada. Should they...
But, Council, clearly there's sometimes reasons outside of the citizens' control, just like at the case at hand where they were not able to find a job in Canada right away. Perhaps there's some other reasons for that. So in the case where there is a person who's interested, who perhaps is involved in some meaningful way in the community from abroad, cannot exercise their constitutional right.
With respect, Your Honor, while this may impact people who have difficulty moving back to Canada, it primarily affects those who have voluntarily chosen to leave the country. Parliament cannot legislate with respect to each individual citizen and their circumstances while abroad, because this encapsulates a great many number of people who are not subjectively or objectively connected to their country. While we are sympathetic to the fact that the respondents...
Is it a great number of people, though? How many people actually outside of Canada vote?
While I believe the number is around 1 or 2 million Canadian citizens outside.
And how many of those people vote?
My understanding is that the number is substantially reduced in the thousands.
So this is a pressing and substantial objective?
Our concern would be regarding the idea that we have a geographically based electoral constituency system.
And that system is under threat because of these few thousand people? Is that, I think, was the number you gave me?
Should any of these citizens vote in an election, one vote could swing the outcome in a riding. As these people vote in a specific riding, this means that their votes could, in theory, substantially affect the outcome in a specific riding. And it is that potential for harm that Parliament intended to address in maintaining the electorate to a group of citizens who are the most concerned with the country and most involved with the country.
Council, could you reconcile that with the special voting certificate? Really, it seems to me it's a mere passage of time that maintains your eligibility to the special voting certificate. So how does that process actually reconcile with your position here about the residency component? If you're 3 years out, you get a special voting certificate and you can vote. You're 4 years out, special voting certificate, you can vote. 6 years out, you no longer have a connection to your community. I'm seeing, how are we going to reconcile that? The mere passage of time somehow determines a connection.
Your Honor, when Parliament does legislate, they do need to assign a number to, or rather it is their choice, and it has been their choice in this instance, to assign a number to this temporal factor. 5 years reflected their choice. Now, Parliament does also legislate on similar matters all the time. Of course, this matter in our submission is akin to the age requirement. Of course, a citizen at 17 years old, 1 day less of 18 might not...
Council, I think that's a false analogy because the criminal code makes special provisions, so it's widely accepted within our community that the age of majority is an appropriate demarcation. Whereas here we're looking at the mere passage of time making the determination for some esoteric, I'm not sure, foreign influence perspective.
Our submission would be that the two requirements are similar in that they are based on experiential qualifications. The age requirement is based on the experiential understanding we have as Canadians that minors do not contain the full capacity to vote, and our understanding is that those Canadian citizens who have been abroad...
So, Council, can you just please, before you proceed, because this particular point turns on experience. Can you make the relationship between experience and specifically living away, particularly at a point in time where the reliance and connectivity that we have using technology virtually eradicates many geographic points of contact? In many ways, people keep in touch and understand their communities through technology more than they do through directly encountering it day to day.
Our submission would be that there are vast differences between someone being connected, whether it be via social media or the internet news outlet, and being substantially impacted by the full burden of the law. Now, Canadian citizens living abroad might maintain an interest. They might check up on Canada regularly. That being said, they are not feeling the full extent of the law on them, which is a substantial difference, and it is the difference that we point to today.
Council, I'd like to direct your attention to paragraph 82 and going back to your minimum impairment argument. Paragraph 82 states, voting is the cornerstone of our democracy, and denying citizens the right to vote not only strikes at the heart of their fundamental rights, but also comes at the expense of their dignity and their sense of self-worth. So basically, you're saying there is a minimal impairment. In my view, there is a substantial impairment by arbitrarily taking away the voting rights, which in this paragraph is a cornerstone of our democracy. How can you reconcile the fact that in survey number 2, incarcerated inmates, they have the right to vote, even though they are removed from society, they are living in their confined environments, and they have no interaction with their supposed communities, while in this case, those Canadian citizens, they have every tie to the community, and they willingly and willfully want to participate in the democratic process. And the government is just taking that away. I feel that is not a minimum impairment.
In answer to that question, Your Honor, in regards to Suave, the distinction we would make on that matter is that inmates are feeling the full burden of the law. They are, in fact,
So do non-residents. We are talking about federal elections, federal laws that they equally affect citizens either here or abroad. What's the difference?
our submission would be that there is a substantial difference and that inmates have many of their liberties restricted as a result of their relationship with the law. They are, again, feeling the full burden of the law in a way.
So is it your submission that convicted criminals have more charter rights than law-abiding Canadian citizens who are living abroad and paying taxes? That's your submission, counsel?
Respectfully, Your Honor, that would not be our submission today. While there are some restrictions, of course, inmates do feel a restriction on their mobility rights and their Section 7 rights. Canadian citizens living abroad may face a temporary suspension of the right should they live outside the country for 5 years or longer.
But from a constitutional perspective, you don't want to suspend the rights of those convicts. So in this case, you are, under a Section 3 analysis, saying that convicted criminals, because you're the one who referenced Sauvé, convicted criminals have greater charter rights, greater Section 3 charter rights, than law-abiding Canadian citizens who just don't happen to live within Canada and are paying taxes.
Our submission would be that these inmates do maintain their charter-protected rights. The intention of these limits is not to base the infringement or base the limit of the right on moral considerations of worthiness, that convicts are more or less worthy than Canadian citizens.
But that's what I heard you make the submission, is that you're saying people are worthy of voting because of their connection to a community. That's what I heard, unless I'm misunderstanding your argument.
Respectfully, Your Honor, we would answer that they are more entitled to vote, as it is a more relevant exercise for them. It's not a matter of worthiness, it's a matter of fairness to the overall system.
Counsel, but what about all those people that are not citizens and still impacted by the community and live in that community for more than 5 years? Do we give them the right to vote then, to balance it out?
Your Honor, to understand your question, you're referencing Canadian citizens within the country? Or
No, I'm referencing people who are not Canadian citizens, such as permanent residents or people who are here on valid visas, who live here for more than 5 years and do participate in the community.
Now, I've been informed that I'm out of time, but I just have a minute to address your question and conclude.
Yes.
With respect to your question, Your Honor, it is our submission that permanent residents do require a certain amount of time in order to gain the entitlement to vote. Clearly, there is a link between time and one's relationship with the community. it actually echoes quite well that it takes a person a certain amount of time to gain this right, and it takes a certain amount of time for someone to have this right suspended. In conclusion, we would submit that the benefit to the overall system is the benefit of effective representation for Canadian citizens. This is a systemic benefit that strikes to the heart of effective representation. As this benefit affects all Canadians, our submission is that the benefits of the measure outweigh the detriments that may attach to certain individual Canadian citizens, and as such, the limit is proportional to its objective. We ask that the court overrule the decision of the lower court and allow the appeal. Barring any further questions, this concludes our submissions today. Thank you.
Thank you, Counsel.
You may proceed.
Good afternoon, Honorable Justices of the Court. My name is Corrado, initial E. To my right is my colleague, Hussein, initial R. And we are here on behalf of the respondents, Dr. Jillian Frank, Mr. Jamie Dong, in the case at bar. It is the respondent's position that the Supreme Court of Canada was correct in their ruling that there was an unreasonable limit on the democratic right to vote under Section 3 of the Canadian Charter of Rights and Freedoms for long-term non-resident Canadians, and we respectfully request that the Supreme Court of the Lions Cup dismiss this appeal and uphold the lower court's decision. The respondent has 4 submissions to make today. Firstly, that while it is a pressing and substantial objective to ensure that electors retain a relation of currency to their community, the social contract should not be the hinge on which Parliament relies. Secondly, that there is not a rational connection between Section 3 limit under the Canadian Charter of Rights and Freedoms and the parliamentary objective that it was designed to achieve. Thirdly, that this infringement substantially impairs the claimant's charter rights. And lastly, that proportionality has not been achieved between the effect of the Section 3 infringement and the parliamentary objective as identified in the Section 1 analysis. I will be addressing the first 2 submissions today, and my colleague will address the final 2. To begin with our first submission, it's the respondent's position that although there is a pressing and substantial objective that must be looked at, as per the 1986 Supreme Court of Canada decision of Regina and Oaks.
What is the pressing and substantial objective in your submission?
The pressing and substantial objective is ensuring that all electors do retain a connection to Canada and their community. And by looking at the Oaks test, we can look at whether the means to achieve this objective has been proportionately weighed.
Is it all electors or all citizens?
All citizens. All citizens of age and term. And furthermore, that the social contract, as our friends spoke to today, is not the means in which this pressing and substantial objective can be looked at. To quote Chief Justice Beverly McLaughlin, as she then was, the right to vote is fundamental to our democracy and cannot be lightly set aside. Limits to it require not deference, but rather careful examination. In order to preserve the objectives of our electoral system, therefore.
But it doesn't mean we can't restrict it, right? That quote that you gave us from McLaughlin says that there are restrictions we can impose. Carefully. And the submission that I heard from your friends is that's what they're doing. They have carefully looked at a 5-year period and said that's what's appropriate here.
Respectfully, what our friends have put forth today is a careful examination of a philosophical social contract rather than concrete reasons why this right should be infringed upon. And it is the respondent's position that looking just at the philosophical level, it is not strong enough to justify an infringement of a fundamental charter right. The values that must be...
What year did this 5-year limit get introduced?
In 1993.
And so prior to that, what was the regime?
Prior to that, non-residents could not vote. As of 1993, under the section restrictions...
At all?
No.
And the charter was still in place at that time, wasn't it?
The charter was in place at that time, but it was deemed that it was an unreasonable limit at that time to not allow not allow non-residents to vote, and therefore measures were put in place to start.
What's your authority for that? At what point did the Supreme Court of Canada or any legal authority determine that to be an unreasonable limit?
Starting in the 1980s, there was a discussion as to whether the changes needed to be made under the Canada's Elections Act, and after discussion, as per 1993, the effects of Section 222 came into effect that would allow non-residents such as those in the military or those employed by the
But that's a
government
legislative decision. That's not a constitutional principle. We're back to the same kind of philosophies we heard from your friends. So why should your philosophy trump their philosophy?
As per the Oakes test, the objective must be of sufficient importance to warrant overriding a fundamentally and constitutionally protected right or freedom, as the right to vote is. And it would be the respondent's position that the social contract is not strong enough to do that. As per the 2003 Supreme Court of Canada decision of the Bureau and Canada, democracy demands that each citizen have a genuine opportunity to participate in governance of the country through the electoral process. If this right were not protected adequately, we would not have a true democracy. We are before the court today because there is a limit that in the respondent's position goes as far as an infringement. And in order to uphold Canada as a true democracy, that must be addressed. In the case at bar, through different levels, the Attorney General of Canada has put forward different objectives. Be that the fairness objective or the social contract.
Well, our
objective.
focus is on the objectives that have been identified by your friends, so let's focus on that.
And speaking to the objectives identified by our friends, that was the social contract, which was what the Attorney General stated in the Court of Appeal, which seems to be as our friends have been taking to date. The social contract can be read as a misinterpretation of the 2002 Supreme Court of Canada decision of Suave in Canada. And as a piece of political philosophy, it's the respondent's position that it is not well suited to withstand the rigors of a Section 1 analysis. Furthermore, Justice Laskin noted that far from offering a compelling rationale for disenfranchising Canadian citizens, the Suave case stands as an uncompromising defense of the right of every Canadian citizen to vote. Furthermore, any argument to this fact has to be taken
Well, but there's a difference between Suave in this case, isn't there? Like some very significant differences.
Suave did deal with individuals who were incarcerated. However, the respondent would submit that when looking purely under the philosophy of the social contract and whether they retain a relation of currency to their local community on the ground, the principle still applies here. Just as the individuals who are incarcerated in prison are not on the ground in their local community with their neighbors in their neighborhoods experiencing that, non-residents also have a different experience.
Well, I also see another difference that the individuals in Suave, as well as the other individuals under the ballot form, so government employees as well as Canadian Forces members, are all under the control, the direct control of the government. That's why their Section 3 Charter implication rights are engaged in a very fundamentally different way. These are individuals who have the full choice and control to return to Canada to exert those charter rights.
While they are under the direct influence of the law, as they are serving a sentence for breaking the law,
Not just influence, but control.
in direct control of the law, it would be erroneous to say that there is no influence of the law over non-residents. And certainly, our friends today have not submitted a reason why a 4.5-year non-resident has any more reason to vote than a 5-year non-resident or someone who's been a non-resident for 6 years. All Canadian citizens, whether they are abroad or in the country, are under the influence of foreign policy. They have the ability to access a Canadian embassy should they need influence.
Isn't the reason because it roughly corresponds with election years?
It does roughly correspond.
So if you don't like an election result, move back to Canada, vote next time around, right?
The issue here is that it is not that simple for an individual to just leave a country where maybe is the only place they've been able to find a stable job and re-enter Canada.
So wouldn't their connection be stronger with that foreign jurisdiction as opposed to Canada? So wouldn't actually their voting represent some type of potential foreign interference? How is that fair to the people who actually grind it out on a day-to-day basis in Canadian society?
Respectfully, Your Honor, it would be the respondent's position that it would not represent foreign interference any more than an individual who is new to the country and has all their family living in Britain. You could say that their influence to Britain could be an extreme foreign interference. However, These are Canadian citizens who have taken the measures to apply under special balloting procedures, something that is not easy for them to do, in order to be able to vote and have a say in Canadian policies.
But Councillor, you can envision the type of circumstances where the totalitarian government rounds up all the Canadian citizens and says, go, vote, and I'm going to tell you who to vote for. Shouldn't we be concerned about that?
Absolutely, we should be concerned about that, and that is why it is the respondent's position that any time that the government attempts to limit the voice of Canadian citizens, be they in the country or abroad, it does represent an issue.
No, what we're ensuring is that people who are voting still have some sort of connection to Canada, not people who, as are discussed in the Supreme Court decision, have potentially never even set foot in Canada their entire lives. These are people who may have had Canadian citizenship, let's say, through 3 or 4 generations, and know nothing. They don't speak English or French, know nothing about Canadian culture or politics, but are just going to vote to influence our foreign policy.
Just as there may be individuals in Canada whose first language or even second language or language at all is not English and French, that does not make them any less Canadian citizens. Furthermore, in speaking to foreign policy, as a Canadian citizen, you are under Canadian foreign policy. That is an absolute, whether you are living abroad or here.
Council, but wouldn't you concede that people who just left or say been out of the country for 6, 7 years are more influenced by the Canadian policy by virtue of maintaining residential ties, as opposed to people who never set their foot in Canada and still yet are Canadian citizens?
Without a poll or study or test of every individual who casts a ballot in our federal elections, it would be an impossible question to answer how connected every individual who's casting a vote is. Furthermore...
No, I don't think that's the question. The question here is that if you are an individual who lives in a different part of the world, maybe has never even known Canada, aren't you going to try to make political decisions in Canada that benefit the country that you're in, not Canada?
It would be the respondent's position that as every Canadian citizen has the right to vote, and it is not Parliament's purview to ask why they're voting along which party lines they're voting for, that would be the democratic choice of that Canadian citizen to make their informed decision for any of the parties that are on the electoral ballot. The parties that are on the electoral ballot are all going to have an interest to Canada. That is why they are the party leaders, and they are the ones...
we have, the Communist Party of Canada. There are many people in Canada who would say, yes, they have a democratic right to exist and to collect votes, but their notion and their vision of what a Canadian democracy means is fundamentally different.
Respectfully, the 0.2% of Canadians that cast a valid ballot from abroad are not enough to elect the Communist Party of Canada into power. And therefore, it is not a pressing and substantial enough objective to the residents on the ground that we are protecting them from the votes of non-resident Canadians, which ties into our second submission and the rational connection here today. While our friends...
Sorry, Councillor. So what you're implying here is that if the numbers of the individuals living outside of Canada did change from 0.2 possibly to much more than that, are then you in a place where you would be suggesting that this absolute right to vote would have to be changed? Or if the numbers changed, are you saying that then the charter right changes? Is that what you're saying?
No, that's not the position of the respondent. The position of the respondent is that because of the spread of where these individuals are coming from in communities, it is not a high enough impairment to the residents on the ground to reconcile the substantial impairment of removing a charter-protected right, the right to vote, from a Canadian citizen.
Well, that sounds like a proportionality argument to me, right? And so if it's a proportionality argument, the question that I'm hearing, if we had different proportions, so 10 million Canadians who are living abroad, would it be a different conclusion then?
If there were 10 million Canadians living abroad, close to a third of the population of Canada, I suppose Parliament would have to look at why that many Canadians were not living in Canada.
But the proportionality analysis would be different, correct?
The proportionality analysis, if it was different in that scenario would likely bring us back to the Supreme Court of Canada, and it could be addressed at that time.
But I guess what I'm getting at and trying to understand your arguments then, you're conceding there's a pressing and substantial objective. You're conceding that, okay? The only argument that you're really hinging anything on is proportionality. Is that correct?
Proportionality is a part of the Oakes test. We have to look at the precedent.
So what else are you? You're conceding pressing and substantial. You're conceding that there's a rational connection, right? You are. The only argument that you have is resting on proportionality. That's what I'm hearing, unless I'm misunderstanding this.
Before I answer the question, I notice I'm running low on time, but I may have an additional
Absolutely.
moment to answer. The respondent does not concede that there is a rational connection under the Oakes test. It is our position that there is not a rational connection, as in the connection. A connection cannot be based on rational considerations, such as the 1993 Supreme Court of Canada decision of Hague in Canada, which was mentioned in the case at bar to plural voting. And the measures cannot be arbitrary or unfair. It's the respondent's position that they are arbitrary here. 5 years is an arbitrary limit. They are unfair to Canadian citizens, and furthermore, they're based on rational considerations of what may happen. For example, a third of Canada moves away, and suddenly foreign policy is completely influencing the citizens on the ground. In conclusion, there's no evidence of the harm that allowing non-residents to vote is meant to address. For over 20 years, it has been possible for certain non-residents to vote, and yet, as per paragraph 63 in the case at bar, there have been no complaints lodged in respect to voting by these non-residents. The 5-year non-residence requirement is unconstitutional, and living outside Canadian soil should not be met with the punishment of losing a fundamental democratic right merely because these individuals exercised their right to leave and enter the country at will. The Section 3 limit is substantially impairing and has not been proportionately balanced, as my colleague will now address in the final 2 submissions. Are there any further questions, Your Honors?
Thank you,
That's it.
Councillor.
Thank you, Councillor.
Thank you.
First 2 submissions.
Proceed, Council.
Good afternoon, Honorable Justices. My name is Hussein, initial R, and I will be making the final 2 submissions on behalf of respondents, Dr. Frank and Mr. Don. Our 3rd submission is that the Section 3 limitation substantially impairs the claimant's charter right. And our 4th and final submission is that there is no proportionality between that limitation and parliamentary objective. To begin, Your Honors, as per the 1995 Supreme Court of Canada decision of R.J.R. MacDonald in Canada, the onus is on the government to show that the measures that they have taken limits the minimally impairs the effect on the protected charter right, and that it is no more than reasonably necessary. In the case at bar, our friends have stated that the government's objective is to maintain fairness, and that individual residents in Canada feel the full burden of the law, and so that would apply to the inmates. But the inconsistency here is that if the objective is to maintain a relationship of currency between the voting community and the candidate that they elect to represent their values and their needs at that time, how could an inmate who has been incarcerated for example, 15 years, be more politically aware than an individual who has their freedom, who has modern technology, who maintains ties with their families, and who pays taxes and owns homes in Canada? People who can come back.
So,
and
Council,
visit.
your position is that there's no temporal limit that would be minimally impairing, is that correct?
Absolutely.
There's no temporal limit at all. So if it's 15 years, if it's 20 years, it's still not minimally impairing.
Absolutely.
Why?
It is our submission here that the same argument for being outside of Canada for more than 5 years can be made for the family members of armed forces and people that work in the service of the government. Sure, the individual, him or herself, may be a branch and an arm of the government, but their families certainly are not. And after 10 years, they could also adopt foreign policies. This cannot be
a halfway decision. It must be absolute one way or another. It must be equal and fair to
I
all
don't think
the
your binary analogy works in this case because they're under the jurisdiction and authority of the Canadian government. That's fundamentally different than having mobility rights being exercised so that you're in another jurisdiction.
I'm glad you brought up that point, Your Honor. The difference here is that the idea and the notion, should this court find in favor of the appellant, the idea that it would give Canadians is as long as you are in control and you are under the control of the government directly, then you can have a right. You are valued for as long as we have you either on our land, obeying our laws, but just because you are Canadian doesn't mean you have a voice. And that directly goes against the 2003 Supreme Court of Canada decision in Figueroa in Canada, where Justice Yakabuchi specifically said that the deleterious effect is that it takes away the possibility of that person having an opinion that forms the social polity in the country that they are from, in the country that they represent.
Okay, Counsel, what you're saying is that Section 3 charter right is an absolute right. Am I understanding you correctly? No limitations on it whatsoever?
No, Your Honor. It is our submission that no right is absolute. That is understandable. As per the
But that's what you were saying. My friend at the end said, listen, it's 5 years, 15 years, 20 years. You said no, we don't want any restrictions whatsoever. Therefore, I would like to bring your attention to paragraph 142 of the case of court. And the end of that, there's a concern. There's a concern in the end, and I concur with that concern. They basically saying that if you say Section 3, right, is absolute,
Yes.
it says then it treats effectively Section 1 as a dead letter, meaning you are creating a hierarchy within charter rights. So then you are creating one super right in a quote. Basically, Section 3 citizenship is the only way, and nothing else, and other rights are inferior. How can you reconcile the two?
As per paragraph 31 of the case at bar, the 2002 Sauvé decision establishes that the right to vote should not be limited by a countervailing collective concern. It must be justified and not indirectly incorporated into the scope of the right itself. It is our submission here that the government is intending to shrink the scope of this right as it was created by the shapers of the charter to have a meaning that it was not intended to mean.
But
and thereby,
in fact, actually, the government extended that right. Previously, of 1993, non-residents would not vote, period. Then they enacted legislation in which they say, hey, actually, you know what? We can give non-resident Canadian citizens the right to vote. Okay, they have to be back within 5 years, and that's the contention. That's the issue here, is the time limitation. And the government made a valid point that Parliament is within its right to enact such a legislation.
it is our submission that 26 years later, it is time for Canada to move forward, to be progressive, to finally be a leader, instead of going and following what other countries, Westminster democracies, have already implemented.
So this sounds like an argument for progressive enfranchisement. Is that correct?
Absolutely, Your Honor.
Is progressive enfranchisement then synonymous with universal enfranchisement?
Universal enfranchisement.
It sounds like that you're making a super right. Other sections in the charter subject to limits. Section 3, no limits.
It is our submission here that the point of Section 1 is to address a practical procedural problem, as it did in Opitz when we
So explain to us, how would you put a limit on this? What's an example of a practical limit on Section 3?
When we speak to Section 3, the historic context of residency matters. It was tied to land ownership, and thereby it went against, it was trying to go against.
Okay, I'll ask it again. Give us an example of a practical limit on Section 3.
The practical limit is what the framers of the Charter put there, citizenship. The framers of the Charter were acutely aware of the concept of residency. They knew Canadians over time would use their mobility rights, travel across the world for educational purposes, for employment purposes, and yet they still did not use residency. They used citizenship. And the reason for that is because they are overlapping concepts.
Counsel, but by following your logic, things change, and things change significantly in the last 26 years. So perhaps, is it possible that those who drafted the charter back in the day didn't contemplate some of the consequences that the word residency versus citizen would mean in the present context right now?
In the event that they didn't contemplate it correctly, we could, A, upheave our entire democracy, the way Canada works, throw away the charter and start from scratch, or enfranchise all Canadians and not limit a specific class of Canadians to not being able to vote. And it is our submission that that is the reasonable option.
Well, I don't think that's the argument. The argument is that in 1876, it probably was a little bit more challenging to travel between Toronto and Hong Kong than it is in 2019.
And yet, in 1986, and again in 1991, and again in 1992, there have been referendums brought forward to make exactly these types of changes. And 26 years later again...
Sorry,
here
which
we are,
types of changes?
to make changes to the Elections Act for residency-based limitations.
But those were made through the legislature.
Oh, they were not made at all. They were referendums that were given and were not implemented.
They were considered through the legislature. So this is where it comes down to a question of deference. Why are we not allowing these complex policy-based decisions to be made by the legislature?
I'm glad you asked that question, because these are not complex, fact-based, evidence-based problems that our friends are submitting. It is a philosophical theory that has no connection.
Well, no. There was a white paper in 1993, as I recall, and so the legislature contemplated this white paper, made some decisions, and actually enfranchised more people than they had before. And you're saying they didn't go far enough. That's really what your submission is.
Absolutely. Just like we did not go far enough when we did not allow people with mental health disabilities to vote, when we did not allow incarcerated people to vote, and now we do. And now the next step is therefore important. It was
Counsel,
noted by...
so why do we go all of a sudden from 5 years limit to all pass for everybody? Can we just maybe set a little bit higher limit of 15 years as was suggested? 20 years perhaps would be a fair result?
Because it is an opportunity for the government to show that it really does care about the opinions of the people that make it a legitimate government.
Council, I think we're running into a bit of a conflict. So what would be the point then of organizing the electoral cycles in regional boundaries? If we're going to say there's no rational connection to the residential requirement, then if I'm here in Ontario, I'll just go and vote in BC for an MP in BC. Like, there has to be some consideration to the residential component.
The majority in the case at bar have indeed considered the importance of residency as an organizing mechanism within the confines of Canada to understand who belongs to which community and who should represent them and how our democracy should work. Outside of Canada, however, those people are still Canadian citizens.
But where do they get to vote? I'm not understanding this. Practically speaking, where do they vote if they don't live in Canada? Which riding do they vote in, or they just get to choose?
It is our submission that, as per R.J.R. Macdonald, the onus is on the government to have these answers, to show that it's minimally impairing. It is our job to show that it is more than minimally impairing. And because the application judge has already noted that it was merely a middle-of-the-road compromise, deference is therefore not owed to it. And that is as per the 2009 Supreme Court of Canada decision of Kiteri Brethren Wilson Colony and Alberta, and further by the 2002 decision of
So
Sauvage.
why should the residency limit apply to residents, but if you're a non-resident, you can vote wherever you want? It seems to be a little unfair here that I'm restricted in where I can vote, but a non-resident is not restricted where they can vote.
Maybe we should all move abroad and then decide where to vote by this logic.
Well, that question actually brings us to our fourth and final submission, which is to consider the effects here. What is salutary, what is deleterious, and which outweighs the other? The salutary effects here is equality, is preserving dignity, is making sure that every Canadian counts, irregardless of where they are in Canada.
Where's the dignity? Where's the humiliation? Where's the oppressive state conduct here that would engage in self-worth and dignity?
The oppressive state conduct is in that inmates who have evaded the law, who have contradicted the law, have that same right, even though they don't reside in these communities.
But they also don't have the choice of moving and living and residing in a community. They just don't have the ability to do it. They are under state control.
And that is the same exact statement that Dr. Frank and Mr. Dong are trying to
So wait, the applicants in this case are under state control?
No, they do not have a choice.
They have a choice to move back to Canada.
They own property. They pay taxes.
They have family here.
They have a passport
And these are all supporting reasons. The
for them to
point
move back to
Is
Canada.
it probably because they were making more money abroad?
It's purely an economic decision on their part.
Exactly.
And so they should bear the consequences of that decision.
In paragraph 161 of the case at bar, the dissent notes that education is one of the reasons that people move abroad, and that 5 years is sufficiently long enough to complete education or to go for employment and come back. However, a Canadian would have to choose between either of the paths, either an education or employment, or a bachelor or a PhD. They cannot have it all.
Couldn't they come back to Canada for a summer, work in a law firm or work for a local company, and then go back to their education?
Absolutely.
And wouldn't that meet the residency requirements?
Not at all. That would be a visit. Most residency requirements require at least 6 months, such as in Quebec, and in Nunavut it's 12 consecutive months. without
Isn't that
having
under the
that.
provincial legislation?
Absolutely, and that's why it's an organizing mechanism. It cannot apply to
So is that the
people.
same requirement that's needed federally as well?
The requirement that is needed federally is the one that is in the charter. It is necessary and it is sufficient and it is citizenship. To conclude, Your Honors, the Attorney General of Canada puts forward a collective concern on an individual right, in which the remedy is to infringe on the rights of a class of citizens.
Well,
Our
Council,
friends
you've already agreed that there's a pressing and substantial need, and you've also validated the residency component. So I'm not entirely certain what your issue now is, because you certainly seem to be supporting the appellant's argument here.
It is our submission that residency is valid to be used as a tool to organize how our democracy works, and one that cannot be used to apply on non-resident citizens. Thank you. If I may continue my sentence.
Please conclude.
And one that cannot apply to non-resident citizens who still have deep ties with their families and who show their civic commitment through going through this extremely long, hard process of appealing, of putting in ballots, of trying, and of visiting. Those are the type of Canadians whose opinion the government should want to make this an effective democracy. We therefore respectfully request this honorable court dismiss this appeal and uphold the lower court's decision.
Thank you,
Are there any
Councilor.
further questions? This concludes the submissions on behalf of the respondent.
Thank you,
Thank
Councilor.
you, Council.